winning isn't easy. Lincoln's seemingly inability to perform a full and fair review of an ERISA disability claims. Now, ERISA regulations require that a disability carrier provide a policyholder or plan beneficiary with a full and fair review before denying and terminating benefits. Lincoln seems to have a hard time doing that. As you read the case law, you will see that that is a criticism of them. Now, the ERISA regulations require that any document, record, or other information considered by them relevant to the claim be produced if it was relied on in making the benefit determination or was submitted, considered, or generated in the course of making the benefit determination. In other words, they have to ask and they have to give. That doesn't always happen, and unfortunately, that doesn't always make a difference to some courts. I'm going to tell you the story found in Hughes versus Lincoln National Life. Hughes was a principal systems engineer and actually worked for Liberty Mutual Insurance Company, which was purchased by Lincoln, the defendant. And this is a case of eating your own, if you will. His position was sedentary and online, but he was on call 24/7. Now, Hughes, like all policyholders or plan beneficiaries, has the burden to prove that they were disabled as that term is defined by the policy or the plan. He claimed that he was disabled as a result of chronic diarrhea, waxing and waning abdominal pain, and bouts of nauseousness and vomiting. Lincoln initially approved his benefits for a period of time until they pulled out their denial playbook. So let's talk about Lincoln's denial playbook tools. It's a toolbox of denial rationales, if you will. And it kind of starts with an investigation of the policy holder. They'll do a background search, and they'll use investigative companies. And in this case, they used Covenant Bridge, which allegedly is an independent full-service investigation company. They scoured Hughes' social media accounts and found a photograph of him knee-deep in snow next to a shovel during a period of time in which he claimed to have uncontrolled diarrhea. Now, he claimed that this was curated reality. In other words, it was staged, and he denied doing any shoveling. Now, of course, Covenant kept on digging, and they found photos of him fishing and kayaking. More digging discovered that he was involved in a newly incorporated business called Virtual On-Site, a property caretaking service. And of course, you know what happens next. The claim was denied, and it ends up in federal court. What did Hughes argue about Lincoln's denial? Well, Hughes argued that Lincoln denied him a full and fair review because he failed to provide him with a copy of the vocational analysis that had concluded that because he could do sedentary work, that there was other work, and he was not entitled to his any occupation benefits. Lincoln, on the other hand, argued that under the First Circuit case law, he had to show both procedural irregularities in the course of the review and that he was prejudiced by these procedural irregularities. In other words, there had to be some connection between the plan's administrator's procedural failure and the inability to receive a full and fair review. Now, you would think that this is a common sense analysis. In other words, if you don't give it to me, how can I respond to it? But in this case, the court said, look, you didn't identify or submit any evidence that you would have provided to Lincoln to develop the record if you had been given an opportunity to respond to the vocational evaluator. To me, that's like gobbledygook. How can you respond to a vocational evaluator's opinion that's only summarized in a denial letter without seeing the report? As a practical matter, I think the court was trying to say that Hughes should have taken the information in the denial letter and challenged it by getting his own VE report. But I think that's stupid. How can a VE write a meaningful report without having the very report that was the basis of the denial? I think, with all due respect to the First Circuit, that this approach to addressing the failure to provide a full and fair review by producing evidence just encourages carriers to hide the ball that the regulations are designed to prevent. The regulations, I think, are really clear. If you considered it, if it was a factor in your decision, it was the basis of your denial, you got to produce it. How hard is that? Well, I guess in the First Circuit, it's pretty tough. What do you think? I hope you've enjoyed this week's episode of Winning Isn't Easy. I hope that you have liked our page. Please leave a review. Please share it. And I would love it if you would subscribe. Please tune in to next week's episode of Winning Isn't Easy to learn more about the games the disability carriers and plans play to deny or terminate benefits. See you then.